All right, the next case is ARAJ versus RENFRO. And how much time would you like for rebuttal?
Like 4 minutes, Your Honor.
Judge Cohen has joined us.
May it please the Court, Elizabeth Russo on behalf of the defendants, appellants, Christina and Jeffrey ARAJ. This case arises from a motor vehicle accident, and we have raised 3 points on appeal for the Court's consideration, each of which seeks a different type of relief. And I'm hoping to get to all 3 points because they're independent of each other. The first one could moot out the rest of them, but if not, we think the others are important, so I'm hoping to get to them. But the first point is that is our position that we believe that an accord and satisfaction was reached when monies were taken that had been given for settlement of the case were taken out of trust account and spent by plaintiff and plaintiff's counsel.
Well, would you agree we're not in a position to decide whether an accord and satisfaction occurred? We're in a position to decide maybe whether there is an abuse of discretion in denying the motion to amend. Isn't that really the issue? I mean, we can't, I mean, can we sit here based on the limited record before us and say as a matter of law there was an accord and satisfaction?
I believe that you could make that decision because...
Well, you have a fact issue based on Mr. Kuhn's testimony alone, right? That he was authorized to expend the money?
Well, we think actually that when you get to that point, if you fast forward to that point, it doesn't really defeat the accord and satisfaction. The funds were put into were given to settle the case.
Satisfaction, a question of fact?
I'm sorry?
Can accord and satisfaction be a question of fact to be determined by a jury or fact finder?
A jury or fact finder, I think the court would have to decide what was appropriate as to that. There can be a fact question as to it. But we think in this instance, but
there wasn't, it's not like we're here, and I realize that based upon the way that it occurred, your position is that you learned this right before trial, but the status that what we've got in our record is really the failure to grant the motion to amend. It seems to me that really is what the issue is here.
Well, and we believe that there was an abuse of discretion in not allowing the amendment. Generally, amendments are supposed to be allowed unless there's been either an abuse of the privilege to amend, which here there was not. We had never tried to amend before, and we raised it as soon as we learned that we had a factual basis for the defense, or if it's going to be prejudicial to the other side, which does not mean, oh, it could end their case, that's not the kind of prejudice, or if it was going to be futile.
All right, you agree, though, that if you prevail on the jury instruction issue, that the other two issues are effectively moot?
Well, we would get a new trial. We think that the...
Get a new trial, you're back in a position where there's no reason not to allow amendment, and we don't know what the verdict would be, so we don't know the limits of liability of one of the plaintiffs, or one of the defendants, rather, correct?
I'm sorry, I'm not understanding the question.
If you prevail on the attorney's fees, on the jury instruction issue, then there's no reason, since you're going back for a new trial, not to allow an amendment, correct? There
wouldn't be, to erase our accord and satisfaction defense?
Correct.
Yes, correct.
All right.
Correct.
And since the verdict would have been set aside, there is no verdict and no reason to determine at this point the limits of liability of one of the defendants.
Oh, I understand what you're saying.
So effectively, those two issues are moot.
They could become moot if we won on the jury instruction issue, yes.
Why don't we start with the jury instruction issue then?
Yes, because we would still be able to presumably proceed with trying to amend.
Right.
The only point I was trying to make before about why I think that the accord and satisfaction defense actually is before the court is because when it was raised to the trial court the first time, again, we found out about the basis for it just before trial. When it was raised to the trial court, he actually ruled on it on the merits. Whether that was right, we of course disagree with his ruling, but his ruling was that there was no accord and satisfaction defense, and the basis for that was plaintiff's position that it doesn't matter what happened to the
I
money.
realize that he said that, but there was never an order entered to that effect, was there?
Well, I suppose, in the sense, we did ask him right afterwards, then does that mean you're denying our motion for leave to amend to add the accord and satisfaction defense? And he said, yes, I am.
Let's go to the jury instruction issue.
On the jury instruction issue, we had, excuse me, just let me get to my notes on that. We had requested a jury instruction, and we have the evidence to support it, but the instruction that we requested was a traffic statute. It's 316.0912 and 316.00333. But basically, the gist of it is, or the instruction that matters is the members of the jury are instructed that no person shall operate upon a limited access facility any vehicle which by its design or condition is incompatible with the safe and expedient movement of traffic. The evidence that we had in support of that is that this accident took place at the top of the Pineda Causeway Bridge over the Indian River, and it's not disputed.
Nicolette was on a scooter, right, on a limited access highway.
I'm sorry?
So the plaintiff in this case was on a scooter, correct?
Yes,
And on this limited access road.
yes,
And your argument was they're not allowed on that road.
that's
And that was
correct.
the purpose of the jury instruction,
Yes,
which was denied.
right?
And then I believe the judge gave the standard, there was another instruction that the judge gave that he felt, for whatever reason, that was more appropriate.
Basically,
to
that
give-
you're not supposed to drive too slowly or something general.
Right. And then there was some argument made in closing argument, correct, that the plaintiff had every right to be driving on that road.
Well, exactly right. So not only did we were entitled under the law to the instruction, you're entitled to get a traffic instruction if you have the evidence to support it, which we did. It wasn't disputed that it was an unlimited access facility. It wasn't disputed that it was 55 miles per hour. This was this scooter had a 1.8
Was
horsepower.
there a minimum speed limit on that road?
Sorry?
Was there a minimum speed
It was not a minimum speed limit, but 55 was
Was
the
there evidence from the Department of Transportation that didn't prohibit scooters from going on that road?
Well, but by law, any vehicle
Was
that
there
can't.
evidence from someone from the Department of Transportation? That's what was as represented by...
I'm just going by the statute. I don't know that scooters are specifically prohibited, but he testified, the Florida Highway Patrol trooper testified that any vehicle traveling at 30 miles per hour on the Pineda Causeway would absolutely hinder the normal flow of traffic. So we think that this had a maximum speed of 30 miles per hour, and he was even going under that. So we think that evidence entitled us to the instruction.
At the time of the accident, was he on an uphill, on an incline?
I believe that he was at the top of the hill, is the description that I got of it. But that was our main defense in the case, was that that vehicle should not have been on that Pineda Causeway at all.
Was there evidence from a DOT official that this was a limited access road?
Yes, Your Honor.
All right. So did anyone give an opinion that this particular vehicle would be prohibited under the statute, or was there just evidence about the nature of the vehicle? And
Well, I don't think that the officer said this would violate the statute, but what he said was that it would absolutely hinder the normal flow of traffic, which is what the statute is prohibiting. If your vehicle cannot go fast enough, and he said any vehicle traveling 30 miles per hour would absolutely hinder the flow. So we think we had the evidence to support the instruction, and as Your Honor points out, if there was any question about whether we were prejudiced by the not giving it, that was our main theory of the case, so vel none, we should have gotten it. But when plaintiff's counsel got up in closing and then said, the fact of the matter is that there were no restrictions on the Pineda, and Mr. Jones was as entitled to be there as any other motorist, when our whole theory was, no, he was not entitled to be there, and when your weighing the comparative negligence, that should be taken into account. So we think that there should be a reversal for a new trial on the basis of the denial of that instruction. Our other point was, had to do with the statutory cap, which, as you point out, Judge Lambert, could be taken care of, except for I think that the trial court, having made the...
I just want to point out to you that I am much better looking than Judge Lambert.
But I think
I'm sorry, Your Honor. I'm sorry. The point of this is, I think we would have to have an explicit ruling on it, since the trial judge already denied the application of the statute or of the statutory cap, so we would need a ruling from the court that he is entitled to the cap. He was the sole owner, the sole title owner, and the wife was driving the car as he loaned it to her as a permissive user. However many times that happened doesn't matter. The statute just says you're entitled to this limitation on your liability. If you're purely vicarious, he was not there. He was just the owner, not the driver. And so any judgment that were to be entered in the future against him should be limited by the statute.
Well, you're not suggesting, if we rule in your favor on the jury instruction issue, that we travel down that path, are you?
Well, I think that otherwise it's going to stand as a ruling of the lower court.
No verdict, though. It becomes an advisory ruling at that point. There's no verdict, there's no judgment against him if we remand this for a new trial. So there's nothing really to rule on at that point.
We just hope to not have to come back up again for that, but...
Times that happens.
I'm happy to answer any more questions. I'm gathering that no further discussion is wanted of the accord and satisfaction at this point. Although I do believe, because the money was taken and spent, even if you take what plaintiff's former counsel said was told to him by the claim representative, he said that he was told that he could use the money only to spend on expenses for Mr. Jones, and that's not what he used the money for.
Well, let me ask this. Had Mr. Coons dispersed the monies prior to his June 3rd email to Kevin Knight?
Yes, he had.
Where he stated that the funds were parked in his trust account?
Yes, he had. He had distributed already fees to himself and to his partner.
It still represented that the monies were parked.
And what he represented to defense counsel was that I have State Farm's limits, and they are parked in my trust account. So he knew, and the plaintiff knew at that point, and from the beginning, the plaintiff signed a release very, very early on, even though they crossed out who the releasee was going to be. So both of them knew what the funds had been given for, and they thereafter both spent them. That's not disputed. So the question is, does it make any difference that we get this surprise testimony 5 and 6.5 years later, whatever, that he had been given permission? When he described the permission that he was given, assuming arguendo that that's true, the permission that he described was to spend the money solely for expenses for Mr. Jones. Since he didn't spend it for that, I think we're back into the accord and satisfaction. They knew, and all the writings in the whole file, the check, the release, the letter that sent it, all said this is to resolve the personal injury claim. They knew that's what it was for, and they took it and spent it on something else. Once they took it, the accord and satisfaction occurred.
But wouldn't you think that State Farm at some point in time would either ask for the return of the money or a release? I mean, are they going to just leave it there indefinitely for years?
Well, I can't speak entirely for State Farm. Our clients are the ARAJs, but it didn't seem to matter to them if they were left parked in the trust account. That's sacrosanct. That just means they're there. So pending further developments, maybe settlement would come up again, or there would be a judgment someday or whatever. I don't think it was incumbent on them to do anything about that. Something in a trust account means it's there, and it won't be released until there's some some official authorization to take it out, something that you've got in writing that shows, all right, now this is where it should go, and that's where it goes. So it's our position that the accord and satisfaction did take place, and it doesn't matter, since he didn't, whatever this conversation was, he didn't pay any attention to it anyway. But what did happen, what we do know, and what was admitted is the funds were in trust, they were there for the purpose of settling the claim, and they were taken out and not spent, and they were just spent on, their own fees or things that the plaintiffs wanted. Some of the money went to the plaintiff herself, and they both knew what it had been given it to them for. And under the law we cited in our briefs of accord and satisfaction, it doesn't matter anymore what you say about it after that. If you knew what it was given to you for, and you took it and spent it, that's it. It's done. It's an accord and satisfaction. So our primary relief we would be asking for would be a reversal for entry of judgment in favor of the defendants on grounds that the accord and satisfaction took place on the evidence you have before you. Otherwise, we would seek reversal for a new trial and not for an advisory opinion. Thank you.
Thank you.
Morning, Your Honors. I'm Roy Wasson, and first, I don't think you could reverse with instructions to enter judgment on accord and satisfaction because I don't think that is an issue in the appeal. I don't think they've appealed the failure to enter judgment. I think it's, as was asked earlier, it's a question of should the amendment have been granted, and it should not have.
Mr. Watson, could Mr. Jones have driven that scooter on I-4?
I didn't hear your question.
Could Mr. Jones have driven his scooter on I-4?
I don't know the answer to that. I don't know if it was a vehicle that fell within that definition of one that by virtue of its design and so forth was incapable of safe operation on that road. I don't know the answer to that, but
But there was evidence that the Pineda Causeway is a limited access facility, correct?
As far as I know, I have no reason to dispute that.
Okay. So why aren't they entitled to the jury instruction on that traffic statute?
Because it was cured by the other instruction that was given. The only reason that a scooter shouldn't be permitted on a limited access road is because it can't go fast enough to keep up with traffic.
Now, you don't think that there's a difference between an argument that says that he shouldn't have been there to begin with versus an instruction that says effectively he's driving too slow for the conditions? You don't think there's a difference between what the jury could do with each of those theories?
No, because if he was going 70 miles an hour there, keeping up with traffic, and there was no reason that he couldn't be seen and keep up with traffic, I don't think that shouldn't have been there to begin with would really be relevant. I think.
But let me talk to you about the instruction that was given. Says Florida statute section 316 says, no person shall drive a motor vehicle at such a slow speed as to impede or block the normal and reasonable movement of traffic, except when reduced speed is necessary for the safe operation or in compliance with law. So if this scooter only goes 35 miles an hour, you can make the argument that that's it. So in order to safely operate this scooter in compliance with the law, then it's not going to be able to reach 55 miles an hour. And so certainly, but there's a huge difference between that and that scooter had no business being on that road anyway because it wasn't allowed on the road for whatever reason. I mean, there's a difference, especially in light of the fact that there was an argument made in closing argument that he had every right to be there. And so given that, why wouldn't the fact that they were denied the opportunity to have their instruction be harmful?
Well, I just can't imagine any reason that the scooter not being able to be there to begin with would be for any reason other than because it cannot keep up with the flow of traffic. It cannot go fast enough to be there safely.
But but perhaps that's the reason. But it goes to their comparative negligence argument. I mean, if there's a difference between, okay, he's just driving too slow, to, well, he shouldn't have been there in the first place. And if you're not there, you're not going to get in an accident. And it goes directly to their comparative negligence argument. The jury could have found that he was 100% negligent and found in favor of the ARAJs, or they could have found he was 50% negligent. But it goes, why doesn't it go directly to that comparative negligence?
I disagree with Your Honor that just being there as when he shouldn't have been there to begin with and was in the accident that supports the giving of that instruction. If this scooter was on the road, well seen by somebody, going the speed limit, keeping up with traffic, and not doing anything wrong, and some driver came and crashed into him and tried to get that instruction in on not being there to begin with, if there's not some factual connection between being on that road in that scooter.
Well, the factual connection is the law says they're not to drive that type of vehicle on that road. And so it is a correct statement of the law to give that instruction.
Well,
It's up for the jury to decide whether it makes a difference or not.
Well, I don't think the instruction should be given unless there is some causal relationship between the violation of the statute and the accident.
Well, there was obviously a causal relationship here because the jury found him 25% negligent.
Well, that's just it. That cured the error in failing to give the instruction, because if that instruction...
I just don't see how you can say that. To be quite honest, I'm having difficulty with that because I think that they basically what the judge did was preclude the ARAJs from the argument that person had no business being on that roadway if they weren't allowed on the roadway. I mean, it goes strictly to their negligence, their comparative negligence argument.
Well, I just continue to disagree with Your Honor that just being there on the roadway in an unauthorized vehicle would warrant the giving of the instruction unless there was some evidence that there was a causal connection between that.
Well, let me ask you this. The judge gave an instruction that says, you can't drive in a way that impedes traffic, in essence. And they asked for instruction that says, if your vehicle is this type, you're not even allowed on the road in the first place.
Right.
All right, so if there wasn't a difference between the two, why is plaintiff's counsel arguing on closing to the jury that he had every right to be there? Why even make the argument? Why isn't your argument just limited to, his only obligation was not to impede traffic?
Well,
why did, it seems to me that, the judge doesn't give an instruction on the law, and then plaintiff's counsel, in essence, gives them an improper instruction on the law.
Well,
or arguably.
all right. If I previously conceded, for any reason, that this vehicle fell within the statute and shouldn't have been there, then I'll try and retract that now and say,
well, let's say, for the jury to make that determination. Mm-hmm. But counsel argued, he didn't argue, that the guy wasn't impeding traffic, Mr. Jones wasn't impeding traffic. He argued he had every right to be there after the judge had taken away the instruction that maybe he didn't. Mm-hmm. And it's for you all to decide.
Well, the only reason I could think of to make that argument is that there was insufficient evidentiary basis to put this vehicle as within that statute, and if counsel had a good faith belief that the vehicle did not.
The jury to determine?
I'm sorry?
Ultimately, isn't that aspect of the statute for the jury to determine?
To me, just being there in violation, I don't think that the statute imposes a strict liability of comparative negligence on the defendant. I think there still has to be a connection between the violation, and to me, the only logical connection is the inability to keep up with traffic, which the jury already found was negligent and awarded the 25% comparative. So couldn't
a jury have found that the plaintiff was comparatively negligent in two respects? One is he chose to drive on a limited access road, one he shouldn't have, and two, he drove so slow as to impede traffic. And then from the defendant's point of view, it's, as far as defendant's negligence, it's that he didn't see, the driver didn't, or I guess she didn't see the moped or whatever it was and struck it, and so there's negligence on her part. But what the jury got, their instruction was they got to consider one act of negligence by the plaintiff, impeding traffic, and they got to consider one act of negligence by the defendant of not seeing the moped, not paying attention or whatever. Whereas if that instruction had been given, they would have had two acts of negligence by the plaintiff. One, the decision to drive on that highway, and two, the decision or the driving in such a manner as to impede traffic.
Well, respectfully, Your Honor, I just can't buy it because let's just imagine that the vehicle is on the road and the witnesses are asked, was anything about this scooter, was anything about the nature of this scooter contribute to the accident? And imagine it was going, like I said before, going the speed limit. Did the speed have anything to do with it? No. Did the guy that crashed into the scooter see the scooter first? Yes. Would the person, the defendant who crashed into it, have seen it any better if it was bigger? No. If all the evidence was
If the scooter wasn't there, would the accident have occurred?
that's like saying if you overslept one morning and took a later route, or you comparatively.
But if you're not lawfully allowed to be on the access highway with that vehicle, if a scooter's not lawfully allowed to be there, I mean, the responding question when the counsel gets up is, if the scooter's not allowed to be there and it's not there, would the accident have occurred? That's a legitimate question, and the answer is no. And so they're deprived of that opportunity.
But if it's just a coincidence, a temporal coincidence of time and place, and there's no connection between that vehicle and the causing of the accident because of the character of that vehicle, I don't think the instruction is appropriate because it's deceiving.
That's like saying when a person runs a stop sign and is hit because they've run the stop sign, that the judge shouldn't give an instruction that you have to stop at stop signs. I mean, that seems like the argument's being made.
I don't quite understand, because if the person was just hit just by coincidence, the
person was hit, and it's horrible. The person was hit, severely injured, and the person was driving on a road which a jury could have found should not have been there.
But how did it lead to the accident? Just by being there,
By being there, it increased the likelihood that there would be an impeding of traffic. Would you agree with that?
Right, and that's
by taking a vehicle that was arguably prohibited from being there, you increase the chances of impeding traffic.
Only because it's going too slow or can't be seen or something of that nature. And I'm sorry, I've given my best on that. I think the purpose of the instruction was satisfied by the too slow instruction and the jury's finding. And I respectfully ask that the court find that any error in the failing to give that instruction did not lead to the verdict, could not have led to the verdict. I need to move over to this big issue.
Let me talk to you about one issue that I have a little bit of a problem with, and that is that State Farm wasn't allowed to present an affidavit from Ms. Diaz. And they weren't allowed to present an affidavit because the plaintiff goes through the charade of calling her to the witness stand at a hearing that occurs 16 months or so after trial, under the theory that, well, this person was subpoenaed for trial, and so they apparently are supposed to be at every event for that case subsequent to trial, and they know that she's not going to be there, and so they go through the charade of trying to call her to the witness stand, and then when she doesn't appear, they make an argument to the judge that you shouldn't allow them to present an affidavit to rebut what Judge Kuntz testified to. Really? Is that a legitimate
Again, there's more to it.
Argument?
There's much more to it than that. There's much more to it than that. Defendant argues on appeal that they had no reason to know that Ms. Diaz would have anything relevant to say about this until till Mr. Kuntz testified, right? But that couldn't be right because, number one, they knew that they had this issue with the alleged accord and satisfaction because they had moved to plead before the trial, and they knew that she was knowledgeable about the facts of this because her name was on the letters, the correspondence that was going back and forth back in 2011 about enclosing the $100,000, and she wrote back and said, I know you can't, you're not going to do it right now. They knew that she was in on those discussions, on those negotiations, and they, way back when,
Is there, there's no evidence that they knew that Judge Kuntz was going to get on the stand and say that State Farm had authorized him to release those funds. In fact, they have an email from him after he had already released the funds saying that I've parked the monies. So there's no evidence that they knew he was going to testify to that fact.
but they knew that Esther Diaz was a material witness to what had gone on in the.
But that's not what the testimony that he gave that was a surprise was. They authorized me to spend that money. Not that there was a conflict over who should be on the release and the timing of the release, but that they authorized the expenditure of those funds. Mm-hmm. And then the plaintiff goes through the charade of calling her, and the judge thinks that that's appropriate, so he's not going to allow an affidavit? I mean, doesn't that seem absurd to you?
Judge, not in light of the fact that there was never any proffer by the defendant that Ms. Diaz would, if permitted to file an affidavit, if permitted to be called at the hearing, would testify that she did not give authority to disperse the funds. Instead, defense counsel said, he gave the weakest excuse for a proffer that I've ever seen. He said, if I'm permitted to call her, if she would say, if any such conversation ever took place, before I go on to the rest of it. So he doesn't even know that whether she was going to testify that there was or was not a conversation. He's just blowing smoke. If such a conversation ever took place, then she would not have told him to spend the funds. Nobody said, the plaintiff didn't say that she told him to spend the funds. The plaintiff said that she permitted him.
But this was a lawyer that had represented State Farm on probably thousands and thousands of cases and had general experience as to what adjusters say and don't say to folks. It just seems to me that that was a charade of trying to call her to the witness stand, and I am troubled by it.
Well, you know what I do when I'm at a trial and a judge won't let me give a proffer or won't let me call a witness or something like this, and I try and say, Judge, may I file an affidavit? And the judge says no. Guess what? I go back and I do it anyway, and I file it, and I type it up, and I file it in the court file, notice of filing the affidavit for the appellate record to show that if I had been permitted to call this witness, here's what she would have said, and we still don't even have that. There was never any post-hearing proffer from her.
Let me ask you this. Was Judge Kuhn's testimony inconsistent with his email?
I'm sorry, about?
Well, actually, I guess it wouldn't be not his testimony. Is his email inconsistent with the trust account records that show money had already been dispersed prior to his email?
I'm not prepared to answer that. I'm sorry. I just didn't prepare for that question.
Okay.
But I have 2 minutes left, and I have to say one thing. Very dispositive thing. That as a matter of law, the requested amendment to plead accord and satisfaction would have been futile because there was no authority to settle. Now, when I raised the lack of authority to settle by counsel, in appellant's reply brief, she did not say, well, you don't need to show authority in an accord and satisfaction case as opposed to a regular settlement case. Instead, she accepted that the law on requiring express firm authority to settle applies in an accord and satisfaction claim, but she raised the ratification exception to authority and made the argument and cited cases including page 6 of reply brief, the Kiz case, to the effect that ratification of an unauthorized settlement occurs when there's an acceptance of the benefit, but the case goes on to say, with knowledge of the facts concerning the settlement. Okay, and so in other words, there would have to be a showing that Ms. Renfro knew that this was $100,000 being offered as settling the case against the ARAJs, and the evidence is to the contrary. There was no evidence that she knew that this was being offered as a complete settlement, and in fact, the only thing that we see is the release that was sent to where they got her to sign a release.
The check said it was in settlement, right? Wasn't there a notation on the check?
Yeah, but for all we know, and there was no evidence of this, for all we know, the evidence would be Mr. Coons told me that this was just a partial settlement and it was okay that we could take the money from my father.
Do you know the date that I know you didn't have an answer for Judge Evander's question, but do you know the date that the funds were dispersed?
I have, yes, sir, in the appendix, in the appellant's appendix. There's a trust account log
You happen to have the date?
that shows the dates here, starting with fees. Starts with May 18th, 2011. But real quick, may I say one more thing? I know my time is up, but in response to the argument that the authority, if given, was only to disperse expenses for the ward, that's, if you look at page of the record 7345 and 7346, Mr. Coons testified that he told Ms. Diaz he needed to use the funds, quote, to open a guardianship account, to open a guardianship itself. And then he has fees and expenses. The judge even noted, he has fees and expenses. So the judge at the hearing interpreted Mr. Coons' testimony to be that the purpose of the dispersals is not just for expenses, but for fees also.
Thank you, you're out of time.
Please affirm the judgment. Thank you.
May it please the court, I think if there are any questions that I can answer specifically about our positions, I'm happy to do so.
Did you take the position that it was a ratification?
We did, and the basis for that is that when the check was very first sent, this accident happened on April 21st, the check was sent on April 27th with a proposed release and saying that it was in full settlement. Plaintiff's counsel wrote back on May 2 with the release signed by the plaintiff herself enclosed. And that release showed on it, now of course they had decided to change the payee, but it showed that it was the $100,000 for full and complete settlement of the claims of the bodily injury claim of her father, Mr. Jones. So she knew from the get-go what the money was and what it had been given for, and she also knew that she then started getting money, even though they never gave the release to the ARAJs, which we had asked for. So,
You may or may
yes.
not know that. That'd be a fact issue, right?
I'm sorry?
That'd be a fact issue whether she knew later on whether release had or hadn't been given.
No, she signed it.
Oh, she signed it initially only as to one party.
Only as the state.
Only as to State Farm.
No, I understand. I'm just saying that that's the record evidence that she actually knew what.
Right.
A lot of times the clients will not, of course, but she did. She knew the amount and she knew what it had been offered for. And I'm saying, and then she knew she didn't give the final release ever. That never happened. There was never a release given to the ARAJs, and yet somehow she was spending the money.
All right. Thank you.
Thank you very much.